To gain insights into how the judges of the Presidential Election Petition Tribunal may deliver their judgment in the coming weeks, it is essential to examine their past decisions in various political and non-political cases they have been involved in. This thorough analysis will provide an understanding of how they might approach critical aspects such as the 25% requirement in Abuja that Tinubu failed to meet and the handling of certificate forgeries. Due to the extensive experience of these judges, this research will be conducted systematically, with each judge examined individually and separate videos dedicated to their findings. Let's begin with Honorable Justice Samane, the presiding judge of the ongoing Presidential Election Petition Tribunal. He has been serving as a judge since the 1990s. Starting as a judge in Bauchi State in 1998, he later advanced to the Court of Appeal in 2010. In 2016, Justice Samane presided over an appeal from individuals arrested by the EFCC for requesting bail after being accused of stealing over 900 billion naira from the central bank. This scheme involved manipulating returned old banknotes, ultimately resulting in the theft of a significant sum. Justice Samane, in agreement with the lower court, denied them bail. This judgment suggests that Justice Samane is an establishment judge who takes a strict approach. It raises questions as to why bail was denied for an available offense, as every accused person is presumed innocent until proven guilty. Therefore, one may draw their own conclusions regarding his stance. Examining Justice Samane's rulings in political cases in 2021, he headed the panel that dismissed the challenge brought by Uche Secondus, the former chairman of the PDP, against his suspension by the Ward ESCO in River State. Many viewed this judgment as controversial since the Ward ESCO lacks the authority to suspend the party chairman. The court ordered that the PDP National Convention proceed as planned, leading to intense power struggles within the party, particularly involving political heavyweights like former Governor White, who were vying for control due to their presidential ambitions. It becomes evident that some judgments may align with the interests of certain parties. While it may seem that Justice Samane was primarily involved in PDP-related matters, he also ruled on cases brought by the APC. For instance, he was among the judges who halted the National Assembly from imposing statutory delegates in presidential primaries. This decision aimed to create a level playing field for candidates outside the government's sphere of influence, such as Bola Tinubu and Atiku Abubakar. Although interpretations may vary, the judgment can be seen as favoring fairness. Additionally, in 2021, Justice Samane halted the execution of a federal high court judgment in River State, which granted River State the authority to collect VAT. Thus, his rulings exhibited both favor and opposition towards different parties. Moving on to address some questions, Michael inquires whether the petition followed the prescribed procedure in requesting documents from INEC and how it might impact their case. During the hearing, the court prevented the Labour Party's legal team from proceeding with a time-bound motion, considering it should have been presented during the pre-hearing stage. The court also noted that the team should have requested subpoenas for INEC commissioners in different states. However, contacting these commissioners proves problematic, as they claim that all certified true copies must come from INEC's Abuja headquarters. The court desired the legal team to serve the commissioners with the subpoena to enforce the law's provisions, which include fines and even imprisonment for non-compliance. The frustration arises from dealing with government agents who should uphold the law but act lawlessly. While the insufficiency of documents may impact the case, having more evidence generally strengthens any legal argument, including election disputes. Consequently, some believe that the outcome might lead to the election's cancellation, necessitating further court proceedings for the resignation of individuals responsible for misconduct in the election process. Regarding Gary's question on the implications of Tinubu's role as ECOWAS chairman, if he were to be removed from office by the court, it is important to clarify that the ECOWAS chairmanship does not shield him from being dismissed from his Nigerian political office. The ECOWAS chairmanship he currently holds has garnered significant attention in Nigeria, but it does not grant immunity from possible removal. Ezra wonders about the scenario if the court orders a recollection of the results and whether Tinubu should step down. If the court mandates a recount, it implies that no winner has been determined yet, and the status quo should be maintained until the results are established after the recount. Finally, Favor asks if Tinubu will participate in a rerun if the court decides on one. It is crucial to understand that the court's judgment will encompass all aspects of the petitioner's claims. Therefore, if Tinubu is not disqualified based on his eligibility at the time of the election and the eventual judgment cancels the election, he will participate in the subsequent election.